And then you went on to say that I really can't say I am guilty because the victim's father is the one who committed these crimes. And he further stated that he's always maintained his innocence. So I'm curious to know what it is that you feel so sorry about.
What do I?
What if you're did you do it or did you not do it?
Yes, I did.
So why did you just tell the officer you didn't do it? You were innocent and that you've always maintained your innocence. Why'd you tell her that?
Uh, uh,
We are about to watch the Connecticut parole hearing of a monster, a stepfather who was found guilty by a jury of his peers for doing the unimaginable to his 4-year-old stepdaughter. Now, this happened 38 years ago when he was 38 years old, and a judge sentenced him to 53 years in prison, and now up for parole again. Now, this happens to be an interesting case in the sense that he seems to have served most of his sentence, which is pretty rare for these type of cases. And we also have appeals. Thank you, Richard, for pulling them up. So we'll be able to go through the acts of the crime and the many different appeals that he has filed in between. Now, here he is at his parole hearing stating before the victim comes up to speak that he's innocent, that it was actually the biological dad that is guilty of the crime. He was not at all guilty, wrongfully convicted. Can you imagine? You can't make it up. But with that, let's jump in.
Eugene Russell,
Inmate number, sir.
11605.
This is a rehear hearing being conducted in consideration of the parole application for Eugene Russell, 011605. He is serving a sentence of 53 years, 24 months, and 30 days jail for what's followed by 3 years probation for sex assault first, sex assault second, 3 counts of risk of injury, assault first, violation of probation on a larceny 6, attempted larceny 5th, 2 counts of larceny 5th, larceny 4th, assault 2nd, larceny 3rd, assault 6th, and a failure to appear 2nd. As of today, records reflect a parole eligibility date of February 27th of 2016 at 50%. There is victim. Yes.
May I just clarify one thing with you? I have 3 counts of the larceny theft.
3 counts of larceny. Yes, 3 counts. Correct.
Yeah.
I have,
Yes.
I don't have that. I'm sorry, Officer Smelly.
Yep.
I have an attempted larceny 5th and then
Yes.
2 counts of larceny 5th. That would be 3. However,
Right.
I heard you say an assault 6. Did you say that?
Larceny.
No, larceny.
Larceny.
Larceny 6, yeah.
Not assault. A larceny
Okay.
6.
Okay.
Yep.
Right. Sorry. Thank you.
No, that's all right. Failure to appear 2nd. As of today, reflect a parole eligibility date of February 27th, 2020, 2016 at 50%. There is victim input in this case. The inmate was heard by the board on July 27th, 2022. He was denied parole and a new hearing date was set for July 2024. The board recommended the inmate successfully complete Track 1 sex offender program, create an adequate release plan, and not receive any new disciplinary reports. As of his last hearing, per his disclosure and a review of the RT, it showed he completed sex treatment, short-term sex treatment program. And he stated he has a release plan in place and ready for the board. Additionally, he received 2 new DRs, disciplinary reports since the last hearing, one for fighting and one for refusing housing. Utilizing the statewide collaborative offender risk evaluation system scores, the offender overall score for recidivate falls within the low range. And utilizing the static 99R, the offender overall score for sexual offense recidivism fall within the low range for recidivism. Mr. Russell, this is your opportunity to express to the board why you believe you should be granted parole. You may begin.
Excuse me. I've served my time. I've taken every advantage of every program that was available to me since I've been in here. I'm sorry for the pain and anguish that I caused my victims, as well as my family. And I hope that I can get out and try to put my life back together and some semblance of I'm sorry, you know, I've been here so long, and I've taken every course I could take. I've done everything I can do. Yeah, I have problems with disciplinary a few times because of what the charges against me. Okay, you know, fights and things like that. I had no choice. You know, if I'm attacked by someone. And I'm sorry for the main thing is I'm sorry, and I just hope that the victims are okay, and I'm sorry.
Okay, Mr. Russell, so we appreciate your opening comments, and as you know, this is rehear for you. And we did ask you were asked to complete the track 1 sex offender program and then do a relapse or a release plan and be able to share with us what you learned in that program that you completed.
And what do you want from me?
So you were supposed to complete the track 1 full sex offender treatment program and share with us how you have benefited from that program.
Oh, well, you know, I've benefited in a bunch of ways. I realized the pain and anguish that I inflicted on the victim. I learned how it ruined me and my family. I mean, nothing could have been any worse that I could think of. I learned this through all the programs that I've taken that the way I lived was just it was terrible, and I you know, if it wasn't for those programs, I probably would be in the state of mind that I am now. You know, I'm sorry for what I did. I've learned look at a victim and know that I caused the pain. And really, I don't know how to put things in words, but you know, I hate the fact that I did what I did. I've learned that it doesn't have to happen, and you know, I really don't know what you want me to say at this point. I'm sorry for everything I did. I served like my time, I hope, and I just want to be home and share some time with my loved ones.
Okay, so Mr. Russell, can you tell us what your release plan is?
Yes, my younger sister Jen, she's 12 years younger than me. She has homes in Massachusetts. She's got a three-bedroom one that she's going to give to me so that I have a place to stay. I'm going to spend the rest of my life in her care, and she's listening to this hearing right now, and so I have a place to go. I have people to fall back on, and I'll be attending any and all programs if that may be imposed upon me.
Okay, so you had previously stated at one time that you'd be going to your son. So that no longer exists. You're now going to live, you want to live with your sister?
Yes.
In
Yes.
Massachusetts.
Yes.
And you are going to attend the sex offender program in the community. What else are you going to do?
I'm going to go to church. I'm going to try to do in all positive things. I wasted my life. I hurt my victims, and I want to be able to turn my life around, and all I can do for the victims at this point, for me, is pray for. And
so, in essence, I heard you say that you realize the pain and anguish that you caused the victim. And I know for quite some time, I was at your last hearing, and you did acknowledge at some point that you committed the offenses, but you sort of minimized what you did. So can you understand, why the victim is so concerned about you going out because you actually minimized what you did?
oh, I'm sorry. I didn't realize that I was minimizing. I probably was. You would know better than me. But I believe me. I hate what I did to them. And if I minimize it, then maybe I have a hard time expressing myself. But believe me, I feel sorry first and foremost for victims, and that's the truth as best I know it. And I can't. Like I say, I'm not very good with words. But I'm sorry, and I'm sorry for minimizing it in their eyes. If that's what they thought.
When was the last time you spoke with your sister?
I speak to my sister pretty much daily.
Are you sure?
Yes.
Tell me the last time you spoke with her.
The last time I spoke with her was about maybe 8 days, 10 days, something like that. But I'm still not sure.
What did you talk about?
What did we talk about?
Yeah.
I talked about first and foremost how she was doing, and all the other members of the family. And I spoke about my parole hearing was coming up, and hopefully, you know, it would work out. And I talked to like brother and sister things. You know, I was anxious, you know, to come before you, that I was hoping to have an opportunity, and
How long have you been incarcerated?
I think I've been good. I think it's 38 years, I think.
So besides your sister, who else is in the community to support you?
No one really. My you know, my family, my mother's father is brother passed away. My family is pretty much my sister and my nieces and nephews.
Okay, so I'm going to go back to something. At your last hearing, we asked you not to get any more disciplinary reports, but you received 2 shortly after the hearing. Can you share a little bit about what happened? There was one in July for refusing housing and one in October for fighting. Can you tell us what those 2 were about?
Yeah.
Madam Chair, I think he said something about that during his opening statement. He said because of his charges, he gets, you know, that's what I thought he said anyway.
Okay. Okay, well, you know, Mr. Russell, I have no further questions. I'm going to turn it over to my colleague, Mr. Rodriguez.
Thank you, Madam Chair. Mr. Russell, so you say when I read your last document that I read, your last interview with the parole officer, you had not provided your sister's phone number or other information. Had you done that?
Have I done that?
Yeah, did you provide that information?
I don't know if I did. I don't know if I did or I didn't.
I'm trying to figure out how you spoke to your sister if you didn't have the number.
If I didn't have what number?
Her telephone number.
No, well, I do have a telephone number.
Why did you give it to the parole officer when you were in the interview? So
Because
she
I
could
didn't
call
know.
and confirm.
Because, okay, at that time, I didn't have my tablet with me, and I didn't know the number offhand, you know.
But when you realized that you needed to give it to her, why hadn't you given it to her already? And the address. Why hadn't you given it to us? They got to confirm that kind of information, because we don't have that confirmed now. So what do we know? Whether you did or you didn't talk to her. You said you didn't. You said you didn't. I think you said you didn't know it. You might say you didn't know it. I don't know. Let's see. Can't remember your sister's address or phone number. And you're saying it's because you didn't have your tablet.
Yeah. If I had my tablet, I would have known it because it would have been there. I probably didn't know it offhand.
I'm sorry. You finished? You finished?
You know, I'm more and more forgetful. You know, the older I get here, it's
Yeah, I can understand that. But at this point, I mean, we would need to confirm that, right? That's part of supposed to be part of your release plan. And the request was to come back with a solid release plan, which meant that you also had to give some thinking to how are you going to set up a support system for yourself when you did go. The world is so different now on the outside than when you came in. Right? So I'm not hearing that from you either as terms of as part of a really solid release plan for yourself.
Well, my release plan, because of my age and the fact that I'm becoming more and more forgetful, is to rely on my sister, okay, and her close knit family, okay, and I'm going to be there in her care, so to speak, and anything I need, she would be happy to help me.
Well, that's something that you know, but that's not something that we know and understand because you didn't provide the information to the parole officer to be able to connect with her. And your sister, I don't believe, has called the parole officer to validate or verify that, in fact, she's going to take care of you. And I mean, I hear what you're saying, but we don't have any verification of that happening. So we have no idea at this point what's going to happen in your release. We have no idea.
Well,
So that's one thing. Second thing is there isn't an added element of support for yourself on the outside because the world is so different at this point. There's nothing that, tells us that you're going to be able to count on individuals to really help you navigate this new environment that you're going to be going into. 38 years. Think, much has changed in 38. They didn't even have cell phones, I think, 38 years ago. You were still using landlines and then phone booths. So, so that's a major concern for me that is not set up for you. The other thing is when you shared about what you learned from, and I appreciate that you apologizing, that you're sorry, because you said it many, many times during this particular interview. I didn't hear really what you got from the work, the participation that you had in the sex offender training or that you participated in the program that you participated in. I didn't hear what you get. Like, what were your triggers? What set you off? What did you learn about yourself? Separate from whatever your apology is for the victim. And again, you said it many times. So that's another concern that I have. I'm not sure what you got from that. And maybe you want to kind of think about it for a second and come back and let us know. Tell us what it is you really got from that program. But because I didn't hear what you got from it. That's not to say you didn't get anything, but I'm not hearing it from you.
Sure. What I did was hideous, and I'm sorry. And I've learned that what I do has consequences. Okay, and I would hope that what all of the years that have gone by, that I've learned. I've learned. I've soaked up every program that is available to me, and I know that I myself, I'm the person who caused this, and I've done everything that I know how to do. Okay, at this point, to alleviate as much of the pain and anguish that I feel, that my family feels, and that the victims feel.
And you've said that, you shared that several times now, and I hear that from you. I really do. But what I'm not hearing is what have you learned for yourself? And
I've learned for myself that I could have been this person long ago, and this would never have happened. But it did happen, and I've learned to take advantage of all the programs I could take advantage of. I did the best I could do in here, even though at times, because of my charges and stuff, I would get to a fight here and there. But all I can say is I'm sorry for what I did.
Yeah, I heard that.
I'm sorry. And
okay, Madam Chair, I don't really have any additional questions.
Okay,
Thank you for answering my questions.
yes.
Ms. Page?
Thank you, Madam Chair. So Mr. Russell, I'm confused. When you were just interviewed by Officer Smelly in preparation for today's hearing, she asked you what you learned since you took the programs, and you made the statement that you realize the cost to the victim and himself and yourself by pleading not guilty. And then you went on to say that I really can't say I am guilty because the victim's father is the one who committed these crimes. And he further stated that he's always maintained his innocence. So I'm curious to know what it is that you feel so sorry about.
What do I,
What if you're did you do it or did you not do it?
yes, I did.
So why did you just tell the officer you didn't do it? You were innocent and that you've always maintained your innocence. Why'd you tell her that?
Uh, uh, Ma'am, I'm sorry for everything that,
Well, you've said that a million times, and I want to know what you're sorry for.
I'm sorry for my crime.
What crime did you, what crime?
Sexual assault.
The sexual assault and what else? How can you be sorry for a sexual assault when you said that their father did it? Her father did it. Which one is it? Are you saying things that you think that we want to hear in hopes that you'll be released from prison? Because that's not how this works, sir. In
No,
order to be a suitable candidate for discretionary parole, well, you have to show us that you have changed. But if you're going back and forth and flipping and flopping and you're not consistent, you're not behaving in the facility, you're taking these programs because you were asked to take the programs, not because you think you need them. And you're saying that you're sorry because you think that it's something that we want to hear. And I have a problem with all
no,
of
I
that.
mean,
I
ma'am,
have a
I'm not.
problem with it all. So I don't have any questions, any further questions, and I thank you, Madam Chair.
Okay, so we have victims' input. And so I would like to hear from the Office of Victim Services.
Madam Chair, good morning, Madam Chair and board members.
Ms. Vasquez?
Yes,
Okay, thank you.
is that better?
Go ahead.
Sorry about that. Good morning, Madam Chair and board members. I do have victim input. The victim of this case has requested that her sister speaks on her behalf. This is your opportunity to unmute yourself and address only the board members, and you may begin.
I just want to say that sitting here listening to him prior to this and hearing anything he said, I was thinking about saying that maybe if he's changed and maybe to come out and get a second chance at life. But sitting here and listening to him make excuses and being very inconsistent with the last time and this time, and the fact that he sat here and blamed my father for the crime, that he was the only one home alone with my sister at the time when all of this happened, is wrong. And for many years, he said he was not guilty. It wasn't him. And then to hear him last time and this time say he is guilty, it was him. He's sorry for this sexual assault. I didn't hear any apology about the beating of my sister, leaving her almost dead. And speaking on her behalf, she's very scared if he was to be released. Doesn't sound like he has a great plan in place coming out, because the last time it was he was going to be with his son. Today it was with his sister. Then not hearing that he provided any of the information that would help him be released and to have somebody helping him. Any thoughts I had, it maybe him getting a second chance at life are gone. I'm scared. My sister's scared if he was to be released. And I hope he stays in for his full sentence.
Okay, thank you.
Thank you, Madam Chair. That is all that I have for this case.
Okay, thank you. So, Mr. Russell, we are going to deliberate on the record. You can listen, but not say anything.
Okay.
So, at the last hearing, we had asked Mr. Russell to complete the Track 1 sex offender program and be able to express how he's benefited from the program. The only two things I heard from him today about that is that he realized the pain and anguish he caused the victim and her family, and that he learned his actions have serious consequences. And that doesn't seem to be enough, because it doesn't go with the interview that was done with the parole officer. Because for some reason in that interview, he said again that he didn't do it and that it was the victim's father. I don't know if what he's confusing that with, but that's what I heard. In regards to the release plan that we asked him to do, he now wants to live with his sister in Massachusetts. And when I asked him who his support system is, he says his sister and her family, and then he's going to go to church. And that's what he said. Then when I asked when last he spoke with his sister, he says 8 to 10 days ago. I asked him to share what he learned, and he said he told her about his parole hearing today, asked her how she and her family were doing and other family members, and that was it. But in reviewing the parole officer's interview, he indicated that he did not have his sister's information and would provide it at a later date. I did ask the parole officer prior to the hearing, and she did indicate that she still has not received it. So I am concerned about what is true, what are the true facts, and what is not. And, you know, Mr. Russell, the only thing I understand is the reason why you had the 2 DRs. And that's because, excuse me, other offenders found out about what your charges are. So I understand that piece of it. But today, I just didn't feel like I heard, number one, that you acknowledge that you committed the offense, what you did to the victim, specifically what you did to the victim, and that's what you're apologizing about. I think the victim's family came here today hoping that at least they would hear some remorse from you, and didn't hear it. Today would have been your opportunity to be allowed to go back out. But I didn't hear, you know, what we'd asked you to do. And there seems to be either some minimizing or some discrepancy about what it is that you actually learned from the program. I was willing to, if I had heard something positive, a good takeaway, the fact that you could say, you know, on September 1st, I spoke to my sister, and, you know, it was in the, it was in the disc that was presented by the parole officer, that, you know, I would have been willing to say, okay, you know, it's been 38 years and you have finally acknowledged what you did, but I didn't hear any of that today, Mr. Russell. Very disappointed. So That's my take. Mrs. Page, did you have any input? And then I'm gonna go to.
Thank you, Madam Chair. So, this is this case alone is very, very concerning. And yes, I understand that Mr. Russell has been down for a number of years and that he has taken all the programs that he could have taken. What I am concerned about is that his behavior in the facility, while I understand the charges are what warrants many of his tickets, 58 is too many. And that's throughout his entire incarceration, and with 2 additional ones since his last hearing. The fact that he's still, he's I don't know. I don't know if it's being manipulative in saying things that he wants to hear. Who tells a parole officer that it was someone else when they know? And that statement is in direct quotes, meaning she wrote that verbatim, what he said. Who says that, knowing that it's going to come before the board and then sits in front of us and says something completely different? I just don't see enough change. I don't think that Mr. Russell has risen to the level of change that I would like to see that would warrant his being released early. And as you stated, Madam Chair, I don't hear a tremendous amount of support in the community that would help him reintegrate successfully and remain a law-abiding citizen and compliant with all the requests of, all of the recommendations and all of the conditions of that parole would have and do. So my vote is to deny him today. And I hate to keep bringing this victim back over and over again, but I would suggest that Mr. Russell come up with a viable release plan and truly work on, I would tell you, don't wing it next time. You really need to write something down if you are given an opportunity for another hearing. That's all I can say. And I mean, we're not here to determine guilt or innocence, but I'm saying be consistent. That's all. And my vote is to deny, Madam Chair, for inadequate evidence of offender change and an inadequate release plan. And I would even add to that poor institutional adjustment. 58 tickets is too many.
Okay. Mr. Rodriguez.
Thank you, Madam Chair. I too find Mr. Russell's all of his inconsistencies. There's just so many of them. And what he's presented to the parole officer, what he's presented to us, the issue with the sister and the phone number and the address, available to him, and he didn't give it. The tickets were also concerning as well for me as well. I am also not in a place right now to also grant discretionary parole at this point. I'm a denial. The question might be, do we want to bring it back again? If he could prepare a solid release plan that provides support in the community, that provides some opportunity for him to be able to put his life together somehow. 38 years, he's done a lot of time. 38 years, the world is extremely different today than when he went in. And I feel he strongly would need that support. I don't hear that today, and that would concern me that he would not have that.
Yeah.
So I'm a denial today, but I would consider to hear from my colleagues if a rehear would be appropriate.
Yeah.
I would be willing to rehear him.
I would, because I came here today with the idea that, after hearing from the victim, I would have been happy to grant the discretionary parole today. And I'm going to say it again, my concern is he wants to go to his sister. He's been incarcerated for 38 years. And no one out there knows Mr. Russell. He's not had contact with anyone. And I asked him, he said he spoke to her 8 to 10 days ago, but the parole officer has nothing. And it is very concerning to me. I could not just put him at a halfway house without knowing that there is some social support. And more importantly, I didn't hear any remorse being expressed for all the cruel things that he did to the victim. I think had he done that, victim and the family would have been happy to say, okay, it's a long time. He did express remorse, whatever, but I did not hear that today. And for me, that was concerning because the victim and the family, they also want to move on with their life. And I would be willing to hear Mr. Russell. It would only be with the understanding that there is direct contact with his family who is going to provide support for him. And I would like Mr. Russell to think about the true impact of the family and think about, expressing some true remorse for what happened to them. So for me, it would be a deny and rehear, and the rehear would be another 2 years.
I have his EOS, Officer Snelly. I have an EOS date of 9/7/28. Is that accurate?
Hold on one second.
Thank you. Madam Chair, I was going to suggest that he be denied for another year.
Just 20, okay.
Just in September 2026. That way, at least he could have a couple years under parole supervision. If
Before
he
he
comes back
goes out.
with a solid plan, because there's not programs that we're asking him to take. It's change that we're seeking, and there's no program for that. That comes from within.
Yes. EOS is 7/21/2027.
I'm sorry, say that once more, Officer Smith.
27.
7/21/2027.
That's a year.
Yes.
It's 2 years, and it gives them a year. It gives them a year on supervision.
So
Well,
he'll only
he
have a
has-
year.
He also has 3 years probation, so we
Yeah.
give him 1 year on discretionary parole. That would be good, and we hate to do this, but this is important. I think not just for us, but for the victim and her family. So in the case of Eugene Russell, inmate number 0011605, there is a motion to deny discretionary parole today for inadequate evidence of offender change, inadequate release plan, and poor institutional adjustment. We would like to give a rehear date of September 2026 with a recommendation that Mr. Russell complete a substantial release plan, which would include where he's going, the information given to the police, to the parole officer.
Madam Chair,
No
I would
DRs.
say, yeah, a viable release plan with identifiable community support, because they're,
Correct.
yeah.
Correct.
As of when he comes back before us, and no DRs, as you said, and there is a second to that motion.
All those in favor,
Right.
by saying aye.
Aye.
Okay. Motion carries. So, Mr. Russell,
Yes,
I hope you heard what the panel said today, and I hope you heard the input from the victim's family. You
yes,
need to do a viable, as Ms. Page said, release plan. And no disciplinary reports.
Yes,
Okay. So we wish you the best of luck.
thank you.
This concludes the hearing for Eugene Russell 011605. Did we state on the record, the rehear month?
Yes, I
Yeah,
said September
September?
2026.
Okay, just to clarify. Great. Mr. Russell, you receive all this in writing. You're all set, okay?
Okay,
Good luck
thank
to
you.
you.
25, 1 year, 2, 1, no.
Oh, I'm
Russell, she said you also.
Yeah.
Mr. Russell,
Russell.
Mr. Russell,
Sit
come
down
back
for a
and sit
second.
down. Mr. Russell, I just need to clarify the new rehear date. So in the case of Eugene Russell, can you swatch it? Let me do it. Is Ms. Page there?
Here,
Sit there for a
I
second.
see your name.
I am here, Madam Chair. I'm just.
She unmuted. Okay.
Yeah,
Okay.
I heard everything that you said.
And I have to do the new date because I said 26 and it should be 25
Okay,
because we did agree on 1 instead of 2.
yes.
Okay.
Done, 27.
Okay, so I'm just going to go back and redo everything.
Yep, I heard it all. Thank you. Go
Okay.
ahead.
So in the case of Eugene Russell, inmate number 011605, there is a motion to deny discretionary parole day for inadequate evidence of offender change, inadequate release plan, and poor institutional adjustment. And the board would like to rehear Mr. Russell September 2025 with the recommendation that he completes a viable release plan and no disciplinary reports. All those in favor? Do I
Aye.
hear a second?
Aye.
Okay.
And this concludes the hearing for Mr. Eugene Russell 011605. Mr. Russell, you will receive all this in writing, okay?
yes, ma'am.
Thank you.
And Mr. Russell, can you make sure you get your sister's information and provide to the parole officer?
Yeah, she listens to this right here now. You know,
Okay,
yes,
And they denied it. And I got to tell you, this was one of those very rare, satisfying hearings where it seemed everybody was just pissed off. They weren't making excuses for him. And, you know, if he had had a viable release plan, they probably still would have granted. I think that's just, they just have nowhere to send him. They don't, yeah, this is a type of ending that we should see more often. And I'll go through the appeal. And you know, this hearing took place in September 20th, 2024, and I'm only getting till it now, January 20th, 2025, and there's going to be a rehearing now in 8 months. So we'll cover it then. If you think that he can actually go 8 months without getting a write-up, or if he's going to actually have a place to go, it seems his sister doesn't want anything to do with him, and I think that's a smart move on her part. Now I'll go over the appeal, and it's of course disturbing. And just in case you were wondering, there were no new parole board members here. Lucky for me, in the spreadsheet server should always marks the parole board members is Chance, Page, and Rodriguez. It's just that I think one of them had a cold, which is why she sounded different. So the petitioner, okay. He has many appeals filed. He's filed so many, which is interesting because you almost wouldn't expect it from what you've seen from him, right? And I think this can also send a message. He seems all disheveled and disorganized, and he's playing games, but he has filed 1, 2, 3, 4, 5 different appeals over the years, which is just more than we're used to seeing. So I'm going to read the one from 2016. And it says, so let's go through this. Petitioner Eugene, after a jury trial, he was convicted of 1 count of sexual assault in the first degree and 1 count of assault in the first degree, 1 count of SA in the second degree, 3 counts of risk of injury to a minor. On August 2nd, 1989, the petitioner was sentenced by the Honorable Judge William L. Haddon to a total effective sentence of 50 years. And the thing is that he has this good time coming up. So I wonder, not his good time, but his full term. So I wonder if he made good time, because the math isn't mathing to me. That's not 50 years, of course. And I haven't seen anywhere that he won years off of his appeals. That part I have not figured out. I tried to have the answer for you before we hit, but I could not figure it out. And okay. The facts leading up to the petitioner's conviction were as follows. The 4 years old. 4 years old. I mean, can you look at him? It's like, you're a different kind of monster. 4 years old. You can still see it, by the way. You see it in his eyes and his mannerisms, the shaking of his head. He's just a vile creature. Okay. So, 4-year-old stepdaughter, the petitioner reported to her first foster mother that the petitioner, Eugene Russell, had been SAing her on a regular basis from September 1986 until March 1987. And that means, like, like you would think, like, it's as soon as basically at 4 years old. I have a 4-year-old. I think she's 8 now. No, 7 and 9. 4, 7, 9. By the way, the idea, that's why I always take it easy when the parole board asks it's a good question to ask. We see Miss Jackson ask it a lot in Louisiana. When they say they're kids, they say, well, how old are they? And it's just why she's asking that is to find out if she has a good relationship with them. And sometimes they skip around the ages, and I never hold them to it because I do the same thing. Okay. Well, but the point I was making is that this is as soon as we know, right? Because it's hard for, it could have been, of course, happening much earlier, and the 4-year-old just could only put a certain date on it, a certain time. Anyways, it's just sick. All the essay occurred when the two were alone together at the family residence in East. The victim indicated that the petitioner forced her to engage in oral and did this with his fingers. On March 2nd, 1987, EMTs and police reported to the petitioner's residence on East Haven on a report of a fall victim. Upon arrival, they found a 4-year-old girl in a semi-conscious condition on a bed. The petitioner, who was at home alone with the child, first reported to those present that she had fallen off a table. That's what we mean by fall victim. The petitioner then gave further contradictory statements. An examination at Yale New Haven Hospital emergency room found that the victim had sustained damage to her brain, bruises on the back of her head, to her body, and several swollen and a severely swollen left eye, a split lip, and cuts on her right ear, chin, and cheek. 4 years old. Counsel for the petitioner argued that his client was 38 years old when he committed these offenses, and that in spite of the heinous nature of the crimes, the petitioner's lengthy criminal history, he did not deserve for what was, for all intents and purposes, a life sentence. Counsel argued that his client will be 91 years old when he's released from incarceration, and he's asking for a reduction in sentence by 15 years. And again, I have not seen that he got this reduction, but he's certainly not about to be 91 years old. He's born in 50. So he must have gotten the 15-year reduction. I just couldn't find it. The petitioner also addressed the court that he stated that he was not the same person he was 30 years ago. He is sorry for the pain and suffering that he caused the victim. During his incarceration, he has obtained the GED. Remember, this was only written recently, right? This was written in decided in 2016, but Sorry for his pain and suffering that he caused the victim. During his incarceration, he obtained a GED, earned college credits, and attended church regularly. And he had a low risk score, ladies and gentlemen. The victim also present in court. She attempted to address the court, but was overwhelmed by emotion. Oh my God! So this monster, I didn't even realize this monster has been putting the victim through this. This appeal actually made it to court. She showed up and couldn't make a statement. I don't know if this was the same victim who spoke today or someone. I think it's supposed to have been someone else. She eventually was able to address the court. Her main concern was that the petitioner never be allowed to have contact with her or her family. It was obvious to the division that even after 30 years, the victim was re-traumatized by the ordeal being in court. And again, this is the thing with the parole hearing. It's like, oh, we'll have another parole hearing in 1 year without taking into account what that does to the victims, right? And I didn't get, whatever, I digress. Counsel for the state argued that the petitioner's sentence was fair 30 years ago and is fair today. After review of the sentencing transcript, counsel for the state argued that it was Judge Hayden's intention to remove the petitioner from society for a lengthy period of time. At the time of the sentencing, Judge Hayden commented that this is the worst case of child SA and physical abuse that I've ever seen. In addition, it is the worst pre-sentence investigation report, as far as the defendant is concerned, that I've ever seen, by the greatest collection of criminal convictions that I've ever seen. I cannot think of a single mitigating factor which tends to help the defendant. I don't know who you are, Judge, but I like you. Pursuant to the Connecticut practice book, the sentence review division is limited in the scope of its review. The division is to determine whether the sentence imposed should be modified because it is inappropriate or disproportionate to the light of the nature of the offense, the character of the offender, the protection of the public interest, and the deterrent of rehabilitative. Isolative, and denunciatory purposes for which the sentence was intended. Whoever wrote this was after me. The division is without authority to modify sentences except in the accordance of the provisions of Connecticut practice. I mean, it is Connecticut, right? They like being fancy with their law stuff. The division finds that there is nothing inappropriate or disproportionate about the sentencing imposed by the court in this case. In reviewing the records as a whole, the division finds that the sentence court action was in accordance with the parameters of Connecticut. Sentence is affirmed. Now, there are other appeals. We're not going to go over it now. There was a few interesting tidbits where I'm sorry to kind of leave you at the cliffhanger here. Maybe I'll drop the link in the description. But there was some discussion about someone in the court making a joke or comment when he was at trial about the jailer who was taking him to court and back to have him get out of the car and run, and then for the jailer to shoot him. So, people in Connecticut, they knew this story, and everyone rightfully hated this monster. And that was said, and then that was brought up in the court. And the whoever said it admitted to saying it. It wasn't, but it didn't affect anything. It was just interesting that they actually said that. Then there was also some name calling and accusations and slur words. It was a messy trial. It was what I gathered, but again, nothing that affected. So maybe I'll share that with you because it is really interesting. Let me share it with you because it is actually unique. So I'll share it with you. It's 6:30 at night. I've been doing recordings since I think 4 a.m, and at a certain point my brain gets fried. And something that I've learned, just so I hope you can take it easy on me when I'm not as thorough or as proficient as I'd like to be. Something that I've learned while doing these recordings is I just do it. I very rarely even do a second recording or a third recording. I do first takes because, as you can see how many recordings I make, if I were to just stop and say, you know what, I'll wait for a better day, which I sometimes do, I would never get anything done. So I'm just proceeding. I'm going with the flow. And for those of you who don't want to watch it, you leave, right? I do it at the end. I don't do it in middle, like, so. Now, so this is an older one. This is interesting. So June 30th, 1989, attorney Wayne Sadek was appointed as a special public defender to represent Russell at trial. At one point during the course of the trial, Russell requested to address the trial court personally. The following colloquy took place. The defendant, Your Honor, on the way back to Somers last night, one of the COs informed me that my attorney... Oh, so this is his attorney. One of the COs informed me that my attorney said to him that he should stop the truck on the side of the road and let me run, and they'd shoot me. Wait, this is his defendant? His attorney said this? No. I feel I'm getting an unfair trial and my attorney is not capable of representing me. I feel that you force him to take this case. No way. The court. Who did? The defendant. You did. The court. I forced your lawyer to take this case? The defendant. Right. He informed you on 2 separate occasions that he was not prepared and needed continuances. They were not granted, and now he's making the statement that the van driver should stop and let me run and shoot me. If this is true, that yes, he needs a new trial, as much as I love it. Okay, I cannot believe that this man has my best interest at heart because this, and I would like this on the record. The court. Mr. Sadek, what about the alleged remarks to the correction officers? Mr. Sadek, so this is his attorney. For the record, the exact intent of the statement was not that. I was kidding around and joking around with the corrections officers. I did not suggest that they stop the car. I just said, in the event of Mr. Russell making an attempt, and it was just in jest and fun due to the outburst during the court that required the court to call recess yesterday. It was not meant literally at all. I'm glad I went over this with you, and thank you, Sir Richard, for finding it. No way. This was, I guess, Connecticut. This could never happen today. I mean, you would think this would be a mistrial. You can't have your attorney even in jest say something like that. I'm for it. I am for it. It's nice to see a defense attorney not wanting to take this. Must have been a case that shook the city in Connecticut. The court, and it's sad to think that these cases don't seem to shake cities anymore. They just brush them under the rug. They just take plea deals. Literally at all. The court, well, Mr. Russell, apparently your lawyer's factitious remarks in jest to the officers were then reported to you by the officers, but not by telling you that it was in jest. You really seriously believe that he was advising the correction officers to shoot you? The defendant. I really believe that's what he said. I believe people say with their mouth what they intend. Doesn't this defendant seem to be much more sophisticated than what we saw today? You know, age does age, but the court. Anything else, sir? The defendant. No, but I do think maybe it was some manipulation here in the courtroom. I don't know. The court. Thank you. You may sit down. The trial's transcript. The trial then proceeded, and Sadek continued to represent Russell. The jury convicted Russell of assault, risk of injury to minor, and SA. He was sentenced to a total of effective sentence of 50 years. Russell's conviction was upheld on direct appeal. When his appeals were exhausted, Russell filed a petition for a writ habeas corpus in state court. After an evidentiary hearing, the state habeas court denied his petition. What was the habeas corpus for? Oh, for this, right? With respect to alleged conflict of interest, Russell provided the following testimony at evidentiary hearing. During the course of the trial, did you become aware of any conflict of interest of the attorney you may have considered representing you? Conflict of interest? Yes. I was transported back to the prison one night after trial. I was told by one of the prison officers that his exact words could have had your attorney's job today. And I asked him what he was talking about. So the CEO says this. Come on, CEO. Russell, his wife, and Patricia Wolf, the attorney representing Russell immediately prior to Static testified the evidentiary. What is this? I don't know. Explained to me that Mr. Static had told him that when they transport me back to the prison, they should stop the van and let me out to take a leak and shoot me in the back just as I was trying to escape. Okay. And you called that court's attention the next day? Yes. There was no further evidence regarding the effect of the statement of Russell's Static's representation of him or his attorney's-client relationship. Russell appealed the dismissal of his habeas corpus, and the trial court dismissed the appeal, denied, You know, it's interesting. It really is. I mean, one would think that he would have won something, but maybe times are a little different then. Or maybe you guys know I don't know much about law. You know much more than I do when it comes to this. So please leave a comment in the comment section if you think that this would have been won. I think it would. To me, it's pretty his amendment habeas, but times have changed, right? We live in a very different world. I wonder what the outburst was at court. And I do wonder where he got the time knocked off, because it's not all 50 or so. The conclusion, the habeas court that considers Russell's petition found that Static's representation was not deficient and there's no conflict of interest between Russell and his attorney. Thus, it is held that Russell's Sixth Amendment right to counsel was not violated despite his trial attorney's inappropriate remarks to the corrections officer. Because the state habeas corpus applied to the correct standard of Russell's habeas petition reasonably applied to the facts of his case, that standard, and based on conclusion, reasonable determination of facts of Russell is not eligible for habeas corpus. Finally, because Russell was not made substantially showing the denial of constitution and was not an issue certificate appealed, Russell amended, but the blah, 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 and he was denied. All right. I mean, it was kind of satisfying to read all of this. I'm happy that we did it, even if we went a little bit over our desired time. I try to keep things in 60 minutes when possible, and I try to keep my unpacking under 20 minutes. This is a long time, but this was worth it. I feel like it's kind of like a time capsule. I don't know if you could have this happen today. And it was risky. Imagine having a mistrial, the pain that would have caused the victims, the trauma. I don't know exactly if the victims had gotten on the stand already. So incredibly irresponsible of the attorney. But it ended up working out. And with that, I'll let you go.
I just want to say that sitting here listening to him prior to this and hearing anything he said, I was thinking about saying that maybe if he's changed and maybe to come out and get a second chance at life. But sitting here and listening to him make excuses and being very inconsistent with the last time and this time, and the fact that he sat here and blamed my father for the crime, that he was the only one home alone with my sister at the time when all of this happened, is wrong.